All right, guys, today we're looking at the HYBE versus Min Hee-jin shareholder ruling from February 12th. And since that verdict was announced a few weeks ago, I have seen a ton of commentary here on YouTube, social media, that's really getting the legal question just fundamentally wrong. I want to use this video from the Haniverse as a case study. So just looking at Hani's YouTube channel, you can tell she's pretty much been following what she has coined as ADORgate for close to 2 years now, so pretty much from the beginning. And ADORgate is really just a legal battle between HYBE, ADOR, Min, and NewJeans. Now, her reaction, calling the ruling quote-unquote bullshit, is a great starting point for discussing why the legal reality of this case is so different from how it's being portrayed on social media and here on YouTube. Now, a quick note on where I'm coming from, since this is my first video on this channel. I am a NewJeans fan. I supported the members during their battle with ADOR, but even then, I had to be realistic about the legal side, and I never thought their contract termination would hold up in court. I believed everything that they were saying. I sympathized with them. I just never believed that their claims were going to be enough to overcome that contract. I don't have a horse in this race between HYBE and Min Hee-jin. I really don't care about labels and producers to that degree. I'm just looking at the law here. Now, the big mistake that I see people making is that they are treating the shareholder contract as though it were a standard HR dispute. So Min had two distinct legal relationships with HYBE. She was one, the CEO of ADOR, which is an employment relationship, and she was also a co-owner with a signed shareholder agreement. So in other words, she was also HYBE's business partner when it came to ADOR. Now, within these two relationships, HYBE is well within their rights to fire her as the CEO if trust breaks down. That makes perfect sense to 80% owners of ADOR. If they don't trust their employee, then they can fire them. But to vaporize a multi-million-dollar ownership right, the law requires a specific executed breach of that contract. So to give you a preview of exactly what I mean, here's what Hani said about 10 minutes into her video.
The resolutions presented in cases where trust is broken don't make sense, because what the court is essentially saying is that even if you didn't trust her, because she had not broken the shareholder agreement, you shouldn't have removed her from the CEO position. AKA, HYBE, in theory, according to this judge, should have just left her be. How would HYBE ever choose to do that?
So in this video, we're going to use Hani's breakdown as a case study to show exactly how conflating these two legal roles leads to the wrong conclusion about the ruling. So let's get into it.
Considering the repetitive and legally weak, defenses that Min Hee-jin's side gave, contrasted against HYBE's concrete and verifiable evidence. And with Min Hee-jin herself getting caught forging court evidence and her lawyers dropping out of the case just days before the final ruling, it seemed like the writing was on the wall. But the court decided otherwise. In a shocking twist, Min Hee-jin was found innocent of violating the shareholder agreement, and HYBE was ordered to pay her full put option, which is valued at just under 26 billion won. And I am here today to tell you why that's some bullshit.
All right, so that was her intro, and she's describing the ruling as a plot twist. And we talked about earlier why she's probably confused. First of all, this was not a criminal case. Min did not have to defend herself in order to be found quote unquote innocent. HYBE was asking the court to confirm the termination. They were the ones that filed the lawsuit, so they actually had the burden to prove a serious executed breach existed at the moment when they filed. Now, the court looked at all of HYBE's evidence, all right? They didn't say it wasn't verifiable. They didn't say it wasn't concrete. But is the evidence actually going to support your case? That's the question there. And the court said no. They still ruled that Min's actions did not amount to material breach that would justify terminating the shareholder agreement. The court stated, according to the SBS Star and some other publications that I saw, the termination grounds claimed by HYBE are abstract or amount to minor auxiliary obligation violations. Considering the severe disadvantage to Min, the loss of her put option, it's hard to see the violations as sufficiently serious to justify the terminations. So the court here is saying, hey, Min has this right, a right under the contract. So if you're going to take that right away from her, you had to have a very good reason to do that. So in a civil contract case, the question isn't, is she a good person? We're not here to talk about if she's truthful or if we can trust her or anything like that. The question is, did what you prove cross the threshold in this contract? So here Hani just completely misrepresents or twists what the outcome was. She takes there is no material breach proven for termination and somehow changes it to quote unquote found innocent in a shocking twist, which isn't even simplifying the outcome. It's just completely rewriting it. So this is just the first 30 seconds of her video, so you can see where it's probably going to go.
As you guys know, I usually try to approach my videos from a more objective and impartial position. And I do that because I want these videos to be kind of news commentary, just me translating the information and letting you guys form your own opinion. So usually I don't give too much of my opinion because I don't want this to be an opinion piece. But today, I I have a lot I want to say. Today I got a lot of thoughts and a lot of feelings, so we're going to do it a bit different. Oh, also.
Okay, fair enough. She's telling us up front this is going to be different from her usual format where she's more objective, she has an impartial position, and she's just translating the information and letting people form their own opinions. So she's saying this video is more of her personal opinion than anything else.
Various parties, news articles, and all that kind of stuff. But unfortunately, the official written verdict is actually not available to us in the public yet. I don't know if that's a time thing because it overlapped with the Lunar New Year or if it's just not going to be available to us. But I've just kind of compiled information from different places. So this is going to be more my understanding as opposed to direct quotes.
And here she's absolutely correct. The written ruling was not publicly available yet when she did her video. Even today, when I'm recording, just about a little over a week after her video, a few weeks after the ruling, it's still not available. Although a few publications seem to have gotten the full ruling, which we'll discuss later in this video. So this is her understanding, apparently no direct quotes, but that's really weird because there are plenty of reputable news organizations that do have actual quotes from the ruling because they were in the courtroom while the judge was reading the ruling out loud for over 2 hours.
This ruling has me absolutely mind-boggled. Not even because of the result itself, but rather because of how the result was justified. When I first introduced the HYBE versus Min Hee-jin case to you guys and I broke down what the premise was and all that kind of stuff, so we're not going to talk about that again today. Go and watch that video.
Since you referenced her older video for the setup, I was curious because I haven't actually seen any of her older videos before this, so I did go back to check this one out, and honestly, she was pretty wrong back then as well. So listen to what she had to say about the overall legal case.
Now, while the question at the heart of the ADOR versus NewJeans case was pretty straightforward, i.e. did ADOR violate the contract terms with NewJeans, justifying their unilateral termination notice? To which we now know the answer is no, but for this case, things are a little bit more complicated.
So first of all, for the ADOR versus NewJeans case, she's saying that was pretty straightforward, and this case between HYBE and Min is quote unquote more complicated. But the thing is that it isn't more complicated. It's pretty much the same legal question. With NewJeans, she rightly points out the issue was, did ADOR violate the terms enough to justify ripping up the contract? Well, for the Min versus HYBE case, the court is pretty much asking the exact same thing. Did Min violate the terms enough to justify HYBE ripping up the shareholder agreement? So it's the exact same standard here, exact same type of contract law that we're looking at. The only reason she thinks it's complicated is because she just doesn't understand what the two sides are actually fighting over. So hear what she has to say next.
There are two disputes taking place here. While both Min Hee-jin and HYBE agree that the shareholder agreement between them has been terminated, they are now battling it out in court to determine who violated the contract and thus who is responsible for the contract termination.
Now, she thinks that both sides agree the shareholder agreement was terminated, but the crazy thing is that the proof she is wrong about that is sitting right there in her own description box. So if you scroll down here in her description and look at one of her sources, she includes an article where Min's own legal team pretty much states the exact opposite. So let's go ahead and open up this article and see exactly what it says. So I just want to focus on these two paragraphs in this article. The lawsuit is expected to focus on whether the termination of the contract between HYBE shareholders was legal. Sejong, which is the lawyers for Min, maintains the position that, quote, under civil law, a contract cannot be unilaterally terminated by either party unless the parties agree or the other party breaches the contract. Her lawyer also emphasized that former CEO Min has never violated the shareholder agreement, and this has been confirmed through the court's injunction order. I mean, an injunction just kind of keeps everything in place. It's not a final ruling, so okay. But she continues. And therefore, HYBE has no right to terminate the shareholder agreement, and HYBE's notice of termination of the shareholder agreement has no effect. The shareholder agreement is still valid, and former CEO Min's rights, such as the put options, are still valid. So those aren't two sides agreeing the contract was terminated. This is Min's legal team aggressively fighting the termination so that she can keep her put option alive. And going back to when she called Min quote unquote innocent, well, this early mistake that she made a few months ago kind of explained why she thinks this new ruling means that. If you think the court is deciding between who gets the blame for a mutually agreed broken contract, then yeah, winning the payout looks like total vindication. But because she built her entire video just on this premise that her own sources are contradicting, then everything that she builds on top of that is pretty much on shaky ground. All right, let's jump back to her video.
I could not for the life of me have predicted the reasoning that the court would give in the way that they gave it. There are parts of it that I can wrap my mind around, but when you look at it in entirety, it doesn't make sense. And not only that, I also feel like it sends a very dangerous message to the industry at large. And it highlights that there are still some fundamental flaws in business and contract law within Korea. And I'm actually going to use one of my own personal anecdotes to illustrate this as well.
Entire legal system is structurally flawed is a huge stretch. I mean, what she's describing isn't really a flaw in the law. It's just the court applied the strict standard of the contract that HYBE agreed to. So if the outcome feels wrong to her, blame the contract and not the law. We'll get into why the quote-unquote industry actually needs the law to work the way that it does later in this video when she addresses their response. And she says she's going to give us her personal anecdote of how the system is really messed up later, so we'll get to that.
I mean, it ultimately came down to, yes, we acknowledge that Min Hee-jin was looking at an exit strategy and may have been taking actions to tamper in later months. But at the time that HYBE filed and said that she had broken the shareholder agreement, at that moment in time, the damage that she'd caused was still intangible. And because she hadn't taken any proactive action to carry out the plans that she was actively making, and moreover, because it would involve HYBE having to give permission or voluntarily agree to participate for her to be able to carry out the plans that she was making.
So here she's actually reciting the judge's logic accurately. So let that sit for a second, but watch what happens next.
For those reasons, we the court fail to see Min Hee-jin's conduct as a breach of the shareholder agreement, even if it constitutes a breach of trust. It's gonna be what? In simple terms, the court is basically saying, yeah, she was gonna do something bad, but because you reacted too quickly, because you reacted before she actually did something, she's still innocent. Because she hasn't done anything that makes her carrying out her shareholder duties impossible, it doesn't count as her having broken the shareholder agreement. It's not a breach.
Okay, this breach of trust thing is what most people are really hanging their hats on when they say the ruling was incorrect. But just think about this logically. Min is a shareholder in ADOR. She's a co-owner and business partner with HYBE. Are you telling me that simply losing trust in someone is enough to take away their contractual right to 25 billion won? Is that the argument people are honestly making? So the judge called HYBE's termination grounds abstract. So here is what the Chosun, reported that the court said in their ruling. HYBE's termination grounds are abstract or minor breaches, insufficient to outweigh the harm Min would suffer from losing the put option. Because how could a court honestly say, HYBE, you didn't actually suffer any tangible damages, but you want me to do tangible damage to Min by taking away her $17 million put option? It just doesn't make logical sense. The whole breach of trust argument is not in the realm of a shareholder agreement. That is in the realm of employment. They can fire her for losing trust in her as the CEO. That's well within their right to have whoever they want in that position leading the company, since they are 80% owners in ADOR. But Min is a shareholder, and this is about the shareholder agreement. So logically, it does not make sense for the court to take away Min's contractual rights because it is quote unquote breach of trust. So when she says quote unquote in simple terms, she left out every term that actually decided the case.
It all boils down to this notion that planning to do something is not the same as doing something in the eyes of corporate or civil law. It's not attempted murder, unfortunately. So it doesn't count, basically.
All right, the attempted murder analogy. So I've seen this in other videos and all over comments and social media, and this is a terrible comparison. If you attempt to murder someone, the victim does not have to give consent. The law punishes the attempt because the whole point is preventing someone from being killed. Min can sketch out all of the Project 1945 scenarios she wants. None of them can actually happen unless HYBE, the 80% owner, agrees to sign off. And that's why this comparison to murder is crazy, because last time I checked, you don't have to get consent to murder someone. You don't have to get consent from a bank to rob it. Now here's what the court said according to the Korea Herald. The fact that Min discussed ADOR's potential independence with outside investors appears to have been premised on HYBE's consent. Without HYBE's approval, such plans will have no legal effect. So the judge is basically saying, you've shown me planning, but you have not shown me a single completed unilateral action that breaks the contract with your own consent. If the courts treated internal planning like attempted murder, every company brainstorming a plan B will be treated as if they've already executed. And that's not how corporate contracts work, and it's exactly why planning versus doing matters here. Back in April 2024, Min said publicly, "It's impossible. HYBE has 80%. I can't do any of this without their consent." HYBE's lawyers heard that and said, "Bold claim, Min. We're going to need 2 years in a courtroom to verify." Seems that she was right.
And playing devil's advocate, someone might say, well, if she won on that premise before, what made you think this was going to be different? What made this difference was the timeline. It's the fact that there has been so much more discovery, not only of the things she's done after that point, but also of the things that she had done prior to that were not known to us or known to HYBE at the time of that first injunction. So bringing all that new evidence to the court should have been what flipped the decision to show that, yeah, she actually had taken action. And I think that's the part of this that I can't understand the most, because essentially this ruling is saying that we, the court, still do not acknowledge that Min Hee-jin did anything wrong prior to when HYBE filed this lawsuit. Now,
Okay, first let me address, this thing about the injunctions. If someone did say that, a really easy thing to say in counter to that is that injunction is temporary. It's usually the court saying, hey, pause everything while we sort this out. Unless you have really, really, really strong evidence up front, they're usually going to kind of be a little conservative and keep the status quo. And the new evidence argument runs into the same wall everything else has. More evidence of planning is still evidence of planning. The court wasn't asking, did she do things? It was asking, did those things constitute a serious executed breach that justifies erasing her contractual exit rights? And the answer was no. No, more evidence in the same category doesn't change the category.
I can argue, I can understand, logically speaking. I don't agree emotionally, I don't agree morally, but logically, legally speaking, if we will, I can understand them saying, well, you filed this lawsuit in July 2024, so we can't use her actions after you filed the lawsuit to justify why you filed the lawsuit. You don't have foresight. So you can only use her actions prior to the lawsuit to say, this is the reason you're suing her, right?
Okay, I'll give her credit. She's at least admitting the legal logic exists, even if she hates it. But then watch what she does next.
But again, she did so much before July. The suspicious contracts with Kim from Banner, that her ex-boyfriend who she's basically siphoned money off, her trying to strong-arm HYBE into changing the conditions of the shareholder agreement to give her the power to carry out the plan that she wrote in the document Project 1945, her meeting with the investors, Neva and Dunamu, who were the ones who even tipped off HYBE, the press conference where she slagged off ILLIT and the Seraphim and basically HYBE as a whole, and the fact that she still has not handed in her laptop to this day for that audit. How do all of these things not count as damage? How do they not count as actions? How do they not count as breaches of her shareholder duties? These are things that she did prior.
Okay, so here she's just rallying off a laundry list and acting like the court ignored it. And they didn't. They just ruled that none of it cleared the bar for an executed breach. Take the Banner contract and siphon money. First of all, it's wild to call it siphoning when the record shows she just promised a cut of her own future payout of her put option to her partner, to her ex. That's her money. That is her money, not ADOR's. HYBE never proved a single dollar of executed loss from that promise. As for strong-arming HYBE and Project 1945, that's just hardball negotiation between business partners. She was pushing for better terms and exploring independent scenarios. People get hung up on these meetings that she had with Navarre and Dunamu or whatever it's called, but think about what she was actually exploring. A buyout scenario. For that to happen, HYBE would have to agree to sell their 80% stake. You can't steal a company from someone who has to sign off on the transaction. Exploring a deal is not the same as executing one. She also brings up the press conference Min had back in 2024 where she mentions ILLIT. We have a whole section on that later. Short answer, the court ruled her comments were professional opinions made to protect ADOR's brand value. Being mean in public isn't a breach of an ownership contract. And this laptop thing, remember those two relationships we've been talking about? Employment and shareholder? Well, the audit and the laptop dispute live entirely in the employment relationship. HYBE was investigating her as the CEO. This has absolutely nothing to do with whether she breached the ownership contract. But even if they found something on that laptop at the point in the timeline, it will still be planning. Same category, same problem. Nothing was actually executed. So Hani at the end is asking, how do these not count as actions? And the court never said they weren't actions. They just weren't breaches. All of this planning and negotiating, and call it scheming if you want to, never caused a single cent of impact on ADOR or HYBE's financial position. So how can you call it a serious executed breach if there's no damage?
But I think there is a little bit of confusion as to what this result means. This result does not clear her of tampering. It doesn't actually clear her of very much wrongdoing in the first place. Even the way that it's worded still acknowledges the fact that she did things wrong. But because it's not relevant whether you think she's guilty of tampering or not, although she is, let's be real, the judge is basically saying that she hadn't done enough yet that is specific to breaking the shareholder agreement for her to be found guilty, despite all the other things she might have done.
Okay, she gets this part right. This isn't a tampering case. Like I explained at the top, the lawsuit wasn't about clearing Min of every possible wrongdoing. It was about one question. And at the moment HYBE filed their lawsuit in July of 2024, had Min actually executed a serious breach of the shareholder agreement? And the answer was no. Nothing had happened yet. All right, this is all planning. You can't win a contract termination case on what you think someone was going to do. If HYBE wants to argue tampering or contract interference, that belongs in a separate lawsuit with different facts. And we're seeing that play out right now. ADOR filed a lawsuit against Danielle, her family, and Min. Those are separate legal actions on separate records. They can fire her, they can sue her, they can pursue criminal charges if they have the evidence. But what they can't do is say, we're so sure she was going to betray us that we don't have to honor the contract that we signed. You don't get to tear up a co-ownership agreement just because you're mad about a laptop or a press conference.
And the thing that also irritated me even more is the judge actually contradicted themselves in the verdict reading, because they said on one hand, oh, she hasn't done anything yet, so you can't hold her accountable for something that hasn't happened. But the judge also said that you got the tip off as early as February, but you didn't take any action until April, which is when the audit happened. So if it was such a big deal, why didn't you act sooner? You're already saying that the point in which we acted is too early, and now you're saying that if we were that concerned, we should have acted sooner. So you don't even believe that we were concerned to take the action that we did. But if we acted sooner, then your argument that we acted too soon would be even stronger. So either way, it's a lose-lose. Judge obviously got confused in those 2 hours that they were talking, because oh my goodness.
All right, here Hani is saying that the judge is confused, which is not true. Hani's just confused as to what the judge was pointing out. So she frames this as some sort of lose-lose paradox where, like I said, the judge is confused and saying HYBE acted too early and too late at the same time. But that's not what he was saying. He's just catching HYBE in 2 different timeline flaws, okay? So first, the too late part. HYBE claims that they had to audit her in April because she was an immediate threat. The judge simply asked, if she's that dangerous, why did you sit on a tip from February and wait until April to do anything? And I feel like that's a pretty reasonable question to ask. If she was that dangerous, why'd you wait a couple months to actually do anything, to act? Second is the too early part. So when the judge says she hadn't done anything yet, he means that when HYBE terminated her shareholder agreement in July, they didn't have an actual executed breach to point to. So by officially pulling the plug in July, HYBE is the one that set the clock. They locked themselves into a timeline that they couldn't even defend. So you delayed any action when you claimed panic, and then you pulled the plug before you had actual evidence. So you tried to borrow facts from the future. If you call that being confused, I don't know what to tell you. Now, some people may ask, well, she didn't exercise her put option until November, so why didn't the judge look at everything she did up until then? Because of Contract Law 101, HYBE officially terminated the contract agreement in July, and if you kill a contract in July, you have to prove you had a valid legal reason in July. Okay, they filed that lawsuit saying, hey, this is when we are, terminating the contract. It's July. You don't get to use these meetings or text messages from the future to justify the July termination. Plus, we have absolutely no idea what the facts would have been if HYBE had just waited. The audit and the lawsuit fundamentally changed her behavior. So after that audit was, made public, what did she do? She held a press conference. So you can't drop a massive public attack on someone, terminate their contract, and then use their defensive reactions to your attack as proof they were planning a breach all along. Now, I want to pause here because since Hani posted her video, we have gotten some more information, some more details from the ruling. And this is from the Sports Kyunghang. I'm not sure how to pronounce that. I don't speak Korean. I'm probably butchering it. No disrespect. But this article is from February 20th, so it was after her video. So I'm not holding her against this for not having this information at all. But I just thought it was important that we read what the court was saying, specifically related to this argument being made by HYBE. So the court stated, Min's protest emails dated April 3rd and April 16, 2024 can be considered as keeping the conflict internal It was HYBE's exclusive article on April 22nd, 2024 that brought the conflict fully into the open. It further noted Min's press conference on April 22nd that immediately follows appears to have been based on her right of rebuttal. So I think it's pretty clear what the judge is saying here. It's HYBE. They're the ones who brought this into the light. They are the ones who brought this public. Because what Min was doing before all of this is that she was just shooting these concerns up the chain to HYBE. All internally. She wasn't going public about this at all. And all that stuff that she was doing in the background, all the quote unquote scheming she was doing, all in the background, nothing public. It wasn't public until HYBE announced this audit via a media leak, which is absolutely crazy governance. Like announcing an audit, especially an audit that isn't even done yet, is pretty crazy for a company to do. And if I was a shareholder of HYBE, I would be upset about that. But you know what? I digress. At the end of the day, the judge here is saying, hey, HYBE, you're the ones who made this public. And it wasn't until you made it public that Min went public with it with her press conference, and that was her right of rebuttal. All right, now jumping down a few paragraphs here, I thought this was also pretty interesting. So the court stated that HYBE's closing stock price fell by a relatively large margin of 7.8% on April 22nd, 2024. This stock decline appears to be the result of the conflict being brought into the open through the exclusive article leaked by HYBE in the subsequent escalation of exchanges between both sides. HYBE claimed an 800 billion won market cap decline in the breach of trust complaint, which appears to reflect the stock price movement. So what the judge is saying is here is, hey, HYBE, you complained about an 800 billion won market cap decline in your breach of trust complaint, but guess what? You were the ones that were responsible for it. You can't blame the fire on Min when you were the ones that lit the match. All right, so that was a lot of information, I admit, and I'm editing this video right now, and even more information has come out. The official ruling is actually out on YouTube, so I might do a video on that a little bit later. We'll see, but anyways, let's go ahead and get back to Hani's video.
Also, another irony in this ruling is that the judge actually did acknowledge that there has been a breakdown of trust. I need someone to explain to me, preferably that judge, how you can expect to continue to do business with somebody when you do not trust each other. And the judge, in effect, acknowledged that the reason that breakdown of trust happened was because of Min Hee-jin. So, okay, she hasn't broken the shareholder agreement, but the trust in which we used to write that shareholder agreement has now been broken. But you're saying that HYBE was supposed to continue working with her? And I think this is actually a fundamental issue of how business and corporate law is written in Korea.
So here we are back to those two relationships again, and Hani just not understanding the difference between Min's employment relationship with HYBE and her shareholder slash business partner relationship with HYBE. So she's asking how you expect two parties to keep working together when trust is gone. And that's a completely fair question in an employment relationship. When your employer doesn't trust you, you're done, you're fired. And that is what HYBE did when they fired her as CEO. But this is not about her job as CEO. This is not about employment. This is about the shareholder agreements. You do not get to rip up a multi-million-dollar put option, a contractual right, just because the vibes got bad. All right. You have to prove an executed breach. Breach of trust is not an executed breach. There has to be something that's actually led to that breach of trust. She had to have done something to cause harm, which led to a breach of trust. Also, she says that the court blamed Min for the breakdown in trust, but nowhere can I find any quotes from the ruling in any of these news organizations that say that Min was responsible for the breakdown in trust. And just as we went over, it was actually HYBE who was the one that was responsible, according to the court, for the breakdown in trust when they did the audit, leaked it to the media. All right. So that's who is actually at fault according to the record that we have. Again, I don't have the full ruling, but that's all the public information we know about who was actually responsible for that. And this isn't the first time Korean courts have said that trust breaking down isn't enough. 3 months before this ruling, the same court decided in the NewJeans case. NewJeans was arguing that ADOR broke their contracts by dismissing Min and destroying the trust relationship. And, well, the court rejected that. So here we have from the Chosun some quotes from that ruling, the NewJeans ruling. The court ruled it is difficult to conclude that merely the fact that Min Hee-jin was dismissed from her position as ADOR CEO caused a gap in management duties for the NewJeans members, or that ADOR lacks the plans or capabilities to perform those duties. It also explained, nowhere in the exclusive contract is it stated that ADOR must entrust the management duties for NewJeans to Min Hee-jin. And merely the fact that NewJeans personally places high trust in Min Hee-jin does not make guarantee her position of ADOR CEO a significant obligation under the exclusive contract. Additionally, the court stated, considering that ADOR's release albums, prepared fan meetings, established world tour plans, and provided opportunities for events and advertising shoots, even without the cooperation of NewJeans, it is difficult to conclude that ADOR cannot be expected to fulfill management services for NewJeans. So back then for the NewJeans case, the court said that a breakdown in trust or just being mad about the CEO changing wasn't enough to terminate a legally binding contract. They needed actual proof of an executed breach in their contracts in order to terminate it. And unfortunately, Min being CEO of ADOR was not part of their contract. And back in October, Hani had absolutely no problem understanding that because she covered the NewJeans ruling as well.
NewJeans' whole argument has always centered on the fact that they believe that Min Hee-jin's dismissal was unfair and Min Hee-jin was the only one protecting them from the company abusing and mistreating them. But we have been saying that unfortunately for you, Min Hee-jin's contract and your contract are two separate issues. Regardless of whether she was unfairly dismissed or not, it's not reason for NewJeans to terminate their contracts. And the judge also said as much in the original first hearing.
And here she perfectly understands the logic here. In October, the court told NewJeans that a breakdown in trust didn't magically erase their contract because ADOR hadn't actually failed its legal duties. In February, the court told HYBE the exact same thing. A breakdown in trust doesn't magically erase Min's shareholder agreement rights because she hadn't actually executed a breach. In both cases, the court separated the emotional breakdown of the relationship from the text of the legal contract. So Hani happily accepted that standard in October, but it seems now that HYBE lost, she's not too happy with it.
And I have my own experience to go on. Some of you may not know this if you haven't been checking my channel community page or if you're watching me for the first time, but I literally just spent the last 2 months in a legal battle with my ex-workplace. I was wrongfully dismissed from my workplace after questioning what I believe to be questionable pay practices. And during the tribunal process, the company actually admitted fault that they did not have the right to fire me under the law. And I was given the option of having my job back. And I literally had to ask the mediator, if you were me, would you feel comfortable going back to a company that fired you incorrectly for asking a question that you had the right to ask? Never answered that question, mind you, and now because they're being held legally accountable, want you to come back? Do you not think you're going to spend every single day with a target on your back? Would you feel comfortable working somewhere where you don't trust the people you're working for and you know they are actively going to be trying to make your life a living hell? Why is that even an option? But also, why is that the thing that you think is the resolution the victim would want?
All right, so she just went through this, personal anecdote, and yeah, it just really kind of shows you that she doesn't understand the difference between being an employee and being a owner with certain rights that exist under a shareholder agreement. Two completely different things. Now, I'm sure her experience is real and I'm not dismissing it at all, right? But her case and Min's case, completely different things.
Now, I'm not trying to defend Min Hee-jin. In this case, technically, by the ruling that we've been given, she's the victim. But the point of the anecdote that I'm sharing is that the resolutions presented in cases where trust is broken don't make sense. Because what the court is essentially saying is that even if you didn't trust her, because she had not broken the shareholder agreement, you shouldn't have removed her from the CEO position. AKA, HYBE, in theory, according to this judge, should have just left her be. How would HYBE ever choose to do that? Bearing in mind, the court acknowledged that she's the one who broke the trust.
Which brings us full circle. I opened the video with this clip, and by now, you don't even need me to explain why it's wrong. You already know the court never said HYBE couldn't fire her as CEO. You already know the difference between an employee and a co-owner. And her personal story is real, but it has absolutely nothing to do with this ruling. So that is pretty much her reaction to the ruling. And now she jumps into like the appeals process. And I'm not going to really touch this part of her video. She's like 95% correct there. Nothing worth me addressing. But there is one thing in this section that I did want to go over.
The fact is, this case serves as the catalyst, the turning point for the industry to make some serious changes. So regardless the outcome of this individual case, there will be a big overhaul of how shareholder agreements are written.
Now remember at the beginning of the video when she said this.
It highlights that there are still some fundamental flaws in business and contract law within Korea.
Well, listen to what she's saying now. Saying the fix is better contracts is pretty much an admission that the judge enforced this contract correctly. The law isn't flawed. HYBE just signed a deal that didn't give them the easy out they wanted. So I'm not sure if she's contradicting herself on purpose or if she just doesn't understand like the difference between contracts and what the law actually says, because yeah, it's very confusing. And ironically, the label executives actually agree with her here. So in her next section of the video, she spends the next few minutes reading a statement from the KEPA, which is basically an industry lobbyist group for the labels. So when she says, quote unquote, the industry, she's really only talking about one side of the industry. She's not talking about the artists and the groups. She's talking about pretty much management, specifically the majority shareholders. Now, their whole argument is that planning a breach should be enough to void a contract.
The ruling could send the message that even if tampering was plotted, as long as it was not carried out or was discovered beforehand, a kind of indulgence can be granted.
But think about why the law actually works the way it does. So put options, the reason that they exist is precisely because minority partners cannot outvote the majority. If the majority wants you gone, they can simply outvote you on every board decision, freeze you out, and really just make your life a living hell. The put option is the only leverage a minority partner has. It's just that guaranteed exit at a fair price no matter what. So if you let the majority void that right over lost trust or unexecuted plans, you pretty much handed them a kill switch. They can make your life impossible and then claim you were planning to leave to strip you of your one protection that you had. Now, I'm sorry, KPA, but no minority partner would ever sign something like that. It's a terrible legal argument. And again, the KPA, they represent the labels, so that's who they speak for. All right, so that was the KPA section and the quote-unquote industry response. Now, next we have the ILLIT plagiarism section, and I definitely have some things to say about this one.
Although we still don't have the full ruling statement, one of the things the judge did mention that infuriated a lot of people, myself included, was a statement which essentially tried to justify Min Hee-jin's attack on ILLIT. The judge said, Min Hee-jin can express her own opinions on the issue of copying. The concept raised by Min Hee-jin is not a method of expression protected by copyright, but merely an idea. Even if the fixed nature of this concept does not receive legal protection, the copying controversy raised by Min Hee-jin seems to be an issue that should be resolved through public discourse.
So listen to this crazy spin here. So in her summary, she claims the judge quote unquote justified an attack, but then she reads the actual quote and the judge didn't say anything about justifying an attack. So here's more of what the ruling said, and you can see why it's much narrower than how she frames it. So according to the court, we have K Bizum here, raising the issue that ILLIT copied NewJeans cannot be viewed as a serious breach of duty. The suspicions raised by Min Hee-jin are considered personal opinions rather than assertions of fact, and therefore do not constitute the dissemination of false information. As the CEO of ADOR at the time, her decision to raise concerns about the similarities in order to protect the value of NewJeans was a managerial judgment made within the scope of her authority to safeguard the company's interest. So what is the judge saying here? Well, in plain language, in this specific shareholder lawsuit, her ILLIT comments were just treated as professional opinion and management judgment, and it was not a serious breach of the shareholders agreement. And really, why would it be? What does ILLIT and ILLIT have to do with ADOR and that shareholder agreement? In no way did the judge declare ILLIT was copied or Min was right about everything that she said. That is not the conclusion the judge reached. The only conclusion he reached was that it did not breach the shareholder agreement. And it's worth noting why the court used the phrase managerial judgment. It's because she was CEO of ADOR. Questioning whether a sister labels group was copying your artist's concept isn't just an opinion. It's her job. It's her fiduciary duty to protect ADOR's assets and NewJeans' brand value. And the court clearly recognized that distinction.
Bearing in mind that the plagiarism accusations and her attack on ILLIT was not even a core part of HYBE's argument, I don't know why the judge felt the need to mention any of this. Because what this statement does is basically give Min Hee-jin a defense to say, look, even the judge said that I was right in saying the things that I said, and I had the right to say those things.
She's asking why the judge even mentioned the ILLIT issue if it wasn't a core part of HYBE's argument. But that framing just assumes the judge just randomly introduced it, like he was online doing searches himself and just brought it up, in the middle of a trial. That's just not how courts work. Judges respond to what the parties argue. So HYBE almost certainly raised Min's public ILLIT comments as evidence that she was acting against company interests, even though that makes absolutely no sense since she is the CEO of ADOR and has absolutely nothing to do with ILLIT and ILLIT. So the judge addressed it here because that's literally his job. Responding to an argument isn't suspicious. It's just standard procedure. So the real question Hani needs to be asking is, why did HYBE bring up this argument? Why did their lawyers bring up this argument? This is pretty stupid in terms of a legal strategy. So what he ruled is complete opposite of vindication. He didn't rule that her plagiarism claims were factually true. He explicitly called them personal opinions and ruled that expressing those opinions didn't cross the threshold of a serious breach. That is all he ruled on. Okay, it's very narrow ruling about the shareholder agreement. And let's not all forget, there is a separate defamation lawsuit against Min that was filed by Belift.
Especially when we take into account the fact that HYBE actually presented evidence of Min Hee-jin instructing employees to dig up dirt on all the groups they could to find something to criticize, which shows that her intention was never pure. It was never that she truly believed that ILLIT copied NewJeans. She simply wanted to find something she could use as an angle to hurt a HYBE group. This is evidence that has been presented in this court case, yet the judge has chosen to ignore all of that and then vindicate Min Hee-jin.
So literally, like, I don't know, what, 30 seconds ago, she was asking, I don't know why the judge felt the need to mention any of this. And then right here, she says, HYBE actually presented evidence of her digging up dirt on ILLIT. That's why the judge mentioned it, because HYBE submitted it as evidence. Oh, Lord. You can't complain that the judge brought up an irrelevant topic and then complain that he ignored HYBE's evidence on the same exact topic. Now, real quick, with this whole digging up dirt claim, this really just shows you that Hani is obsessed with Min's intent. She wants the judge to punish Min for having impure motives, as she says. But once again, she's confusing like an HR employment dispute with a shareholder contract. Even if Min was being completely cutthroat and playing dirty PR games against a sister label, that makes her more of a toxic colleague. And guess what? HYBE did fire her as CEO for that. So they took care of that. But this isn't a HR employment dispute. It's a lawsuit about whether that toxic behavior legally erases her right under the shareholder agreement. So the threshold for that isn't was she mean to ILLIT. The threshold was, did she cause serious financial harm to ADOR? That's what the shareholder agreement is related to. It's not related to Belift. So if HYBE wants to argue that her media campaign that she was planning was malicious, a premeditated attack, they had to do that in a defamation lawsuit. And, like I said, that is what they're doing with the Belift defamation case against her.
Out of everything that happened from this ruling, I actually do genuinely feel that statement from the judge about ILLIT was so unnecessary. And that is honestly the part that makes me feel the most suspicious and the most concerned for what could happen next. And I know there's been a lot of talk about like how corrupt is the legal system in Korea. And I'm not gonna lie, I think it's corrupt too. I don't know if this judge necessarily is in the pocket of Min Hee-jin, but I definitely feel like that was weird. That's suspicious, if you know what I mean.
Okay, so let's be very clear about what just happened here, all right? She spent this entire section not understanding why the judge addressed the ILLIT argument. And we just explained why. Judges respond to the evidence the parties submit. So that's not weird. That's just how the standard legal procedure works. So this corruption allegation is pretty crazy. I mean, it isn't based on actual evidence of corruption. It's based just purely on her not understanding why a judge did something that's completely normal. And if you look closely, we've actually been, tracking exactly how this happens throughout her entire video. She started with the wrong legal framework, taking employment logic and applying it to a shareholder agreement case. And then when the ruling naturally didn't match that framework, it just felt wrong to her. And when it kept feeling wrong, then the explanation became, oh, the system must be corrupt. All right, so that was her ILLIT section, and I have a lot to say about that case, but I'm going to save it for another video. I thought about putting it here in this section, but it'll just spend too much. So maybe I'll do another video on that later. But jumping back into the Hani video, her next section here, she's just going over the effects of this case on the ADOR lawsuit versus Danielle, Min, and her family member. I'm not going to go through the entire section, just some of the few clips that I thought were key.
How will this affect the Danielle case? Because unfortunately, it is the same judge. And mind you, this is referring to the ADOR lawsuit against Min Hee-jin, Danielle, and her mum for damages and tampering. Personally, I would say that while I'm suspicious, I am still not entirely concerned yet. And the reason I say that is because the judge did pretty much acknowledge Min Hee-jin's tampering, even in this ruling, or at least her intention to participate in tampering, making NewJeans independent, all that kind of stuff, right?
Okay, so first of all, quick correction here. The judge did not acknowledge tampering. He just acknowledged that Min explored ways to make ADOR independent and weaken HYBE's control, and then said those plans assumed HYBE's consent and didn't amount to a breach in an agreement. That was the ruling, okay? Planning and tampering are not the same thing. So that distinction matters for the ADOR case, but for here, that's not what he was saying. So ADOR cannot come back to this case and say, hey, look, the judge proved tampering. That's not what was happening here. So I just want to make sure that's clear.
And the importance of highlighting tangible actions over intentions, because that seemed to be the issue with this ruling. There was a lot of intention, but there was no action. So now ADOR knows, okay, we need to bring plenty of evidence of action at the forefront of our argument. Timing wise as well, as we said, HYBE had this issue of like, they couldn't use anything Min Hee-jin had done after they had sued her, whereas ADOR now has everything she's done up until this point as things that have happened before they levied the tampering case against her. So now they can use all of that, and that she hasn't done anything yet narrative can't stick.
And she's right that ADOR can now use evidence from the last 2 years that HYBE couldn't. So HYBE was just locked in to that evidence before, July 2024 when they filed the lawsuit to terminate the contract. In a damages case like what ADOR has, showing intent helps prove that the harm was deliberate. But, and this is a big part that Hani is kind of missing on, is that deliberateness doesn't matter if you can't prove causation. So ADOR has to prove that Min's specific actions directly cause the financial loss that they're claiming. Now, I'm not sure if HYBE is actually claiming this, but we've already seen the judge say that, hey, that drop in your market value and your stock price of roughly 8%, well, that was actually because of what you did, your hasty audit, making it public, the excessive media play, that's all on you. But again, I'm not sure if HYBE is even making that argument in this case, but that's just kind of the thing you have to think about. There has to be a direct causation from what Min did to the actual damage that HYBE suffered.
As I keep saying, I think a lot of people seem to forget that this HYBE case was never a tampering case. The premise, the legal question were completely different. So even though this ruling is so annoying, and even though this ruling really, in my personal opinion, it still missed the mark, it doesn't negate a lot of the argument. In fact, it's actually given a lot of credit to some of the arguments that ADOR is going to push against Min Hee-jin. And even though the court did acknowledge that a breach of the shareholder agreement didn't take place, it doesn't mean that the courts acknowledge that tampering didn't take place.
Okay, she's correct. Like I said, this was not a tampering case, but I love to know who she thinks she's talking to when she says a lot of people seem to forget that. Because for the last 35 minutes, she's pretty much been treating this like it was an actual tampering case.
In a shocking twist, Min Hee-jin was found innocent of violating the shareholder agreement. It's not attempted murder, unfortunately. How do all of these things not count as damage? How do they not count as actions? How do they not count as breaches of her shareholder duty? The damage that she'd caused was still intangible.
That's not the analysis of someone who understood that this was a contract case. That seems to be more of a reaction of someone who was expecting a tampering verdict and didn't actually get one. And then next, she does raise the ILLIT or source music defamation cases against Min. If they win their cases against Min, HYBE might try to use those rulings as fresh grounds for termination. I highly doubt that because ILLIT and the source music defamation cases, they really have absolutely no bearing on her shareholder agreement. Unless her agreement specifically said something like, hey, Min's not allowed to actually say anything bad about other HYBE labels in public or defame them, quote unquote, defame them, then yeah, it's not going to matter what happens in those cases. It has to be explicitly in her shareholder agreement, which I doubt actually says that. But even if it does say that, it still has to be a serious enough breach to wipe away her put option rights in that contract.
Right now, I would first like to see the actual complete written statement in its entirety for this verdict. Although I'm not sure we ever will be able to, because I don't know if they're going to actually release it or not. But if they do, and I think that's something worth talking about, maybe we'll do another video where we actually go through the points that the judge made and then talk about whether we agree or disagree or why that might be the conclusion.
But do you think it would really matter if she had the full ruling? I mean, there are already plenty of direct quotes and detailed breakdowns of the ruling out there from various news organizations, and she still got the fundamental law wrong. She spent 37 minutes or so fighting a tampering case, essentially, that wasn't happening, and using labor law to debunk a shareholder agreement contract. So waiting for the full text isn't going to fix a fundamental misunderstanding of how business law works. Like I said before, the big giveaway that she doesn't understand what's going on is thinking that her personal anecdote of what happened to her between her and her employer was actually the same as what's happening here with Min and HYBE. Now, as far as the future of this channel, I'm not sure what I'm going to do. I really only created this channel just to address this one video and this misunderstanding that I've been seeing all over social media. So we'll see. I do have like other YouTube channels that I manage, plus I have a full-time job. So I'm not going to dedicate too much time with this, but I may address some of the other legal cases around, as Hani says, ADORgate. Feel free to leave any comments down below. If I say anything that you disagree with or you have a rebuttal, I will address any comment I see, which I'm not expecting to get a lot since this is a brand new channel. But yeah, I'll address all comments. Thanks for watching. Peace.